So in every meeting, as I said before, we have a speaker, Sue, and the second half of the meeting is what we call pitching panel, where we have an entrepreneur come in who has a new business, a new product, and is looking to present it to our group and a panel of experts, which includes some of our professional members. And it's like Shark Tank, but without the theatrics and money. And it's really to help people get smarter through the benefit of the experts and the audience. So what Lance asked about a couple of months ago, we had a gentleman who, two gentlemen who invented what's called Safe Harness, and it's the first and only personal portable seatbelt for use on coach buses. I kind of liken it to calling it a BYOB, bring your own belt. And so Lance, they just launched a few weeks ago their crowdfunding campaign on Indiegogo. So you guys might want to go, if you're going to Indiegogo and you like the idea, support them. And it's going okay. It's a build. They seem to be getting some momentum in the past week. Might be a tough time of year to launch, but since day camps use a lot of coach buses, they thought there might be some good synergy with that. The other gentleman who presented during pitch panel, he has a product called Milk Magic. And I can't give you all the details, but he was very fortunate in that, so what he presented to the group was that he did his own test of a infomercial, an as seen on TV, 1999. And he, please come on in. The test was really lukewarm to poor. But everyone who sees the item says it's cool. I like the fact that you can make a latte or foam your milk without having to have a big machine, $1,000 machine. You just shake the milk and it foams it, and then you could spoon it out onto your coffee. It didn't do so well in his infomercial test. But everyone he spoke to said it's a great idea. Maybe you just didn't know that category so well, and he found a partner, and he does now have a licensing agreement with another company who was going to take it forward for him both on television and to retail. So that was an interesting success story, and a lot of his readjustment of his thinking came about from being in this room in particular. So
thanks a lot.
You're welcome. You're welcome. No, it's good to revisit some of that, and I think at one of our meetings will be some of our pitching panel people revisited, a year or two later even. So with that, as I mentioned, we have some professional members, and I'd love to introduce them all to you. Gordon, you want to say hello?
Hi, my name is Gordon Randall Perry. I'm an industrial designer, and I work with people like yourself, inventors, entrepreneurs. And basically what we do is we help you design the product. If it's just an idea you have in your head, a sketch, a little model, wherever that you go, I'll take you from there all the way to pilot production if that's what you need. So I can do the design, the engineering, the whole 9 yards for you. I'm in Greenwich Village, so easily to find. I'm also on the website, so I encourage you to give me a call. Thank you.
And Louis Del Judas, our host here at Troutman and Sanders. Please welcome.
Hello, everybody. I'm Dave. I'm a patent attorney here at Troutman and Partner here. We have a number of professional patent partners, both in this office and as members who work in the space. I'm happy to help. Come on by when you're quiet session, talk and answer some questions. I realize that my rate may be a little high for some startup inventors, but we can talk about that. I have good leads, I have some contacts, we can help you get along. I can either be your attorney or I can be a good resource to help you find an attorney. So you're welcome.
And he is not just saying that for the sake of saying that. I think, as I said at the beginning, the organization is about really trying to provide good support systems for everyone. And with that, David.
Hi, everybody. My name is David Postalski. I'm an intellectual property attorney at Patents, Trademarks, Copyrights with the law firm of Dave Pitney. We have offices up and down the East Coast, from Boston all the way down to New York City. What our claim to fame has been in the last few years is helping entrepreneurs and startups kind of get situated with their intellectual property, whether it's a crowdfunding campaign or it's actually introducing people like Gordon or even to people like Louis to get really big. So if you need any assistance, I'm here for you as well.
Thank you, David. And by the way, I didn't introduce myself before. My name is Bruce Zutler. I'm the president of the association. I also operate a company called MCI Products Group, and our goal is to help empower people to become experts in their own invention, from invention to implementation. With that, we should thank David Kostalski. David knows Sue Purvis from the US Patent and Trademark Office and suggested to me that we might want to invite her because she has some great background in understanding how the Patent and Trademark Office works, why it's there to help individual inventors like us, and what we don't know already. So with that, I would like to introduce you to Sue.
So I have a lot of slides, but I don't want to talk from the slides. So if you have questions, please interrupt me. That's when that's when I'll really reveal information, is when you ask me questions. So
Off the record? Is it off the record?
No, no. Everything I say is completely on the record. I've worked for the PTO, and I'll talk a little bit about myself right now. I've actually worked for the PTO. I always do that. I've worked for the PTO for almost 15 years. Actually, my 15-year anniversary is coming. Oh, it's passed. I have worked for the PTO for 15 years as of like 2 days ago. So when I started at the PTO, I graduated from Ohio State with a chemical engineering degree. I got a job offer in Cleveland. I'm like, I'm from Dayton area. I don't want to live at the Mistake by the Lake. I want to. So the other job offer I got was actually with the USPTO, and I was like, oh, this is interesting. I never really thought about being a patent examiner. I went to school for engineering, and I worked for a company, and but no, the PTO hires engineers. They hire engineers because they need engineers to understand the inventions coming in the door. We can't hire history majors. We can't hire English majors. We need engineers, scientists, and engineers. So I went to the PTO. After a couple of years, I actually went to law school. So I was actually working full time and going law school at night. If you want to not have a life for 4 years, I recommend working full time and going law school at night. But it was, it was great. I graduated, and I just decided. A lot of my peers that I went to George Washington University, and a lot of the peers some peers at the PTO actually went there too, and many of them left, some of them stayed. I decided to stay on because I got a lot of interesting possibilities at the PTO. I progressed as an examiner, became a primary examiner, and as an inventor. If you've ever prosecuted a case as a pro se inventor, the primary examiner is the one that signs the office action, or the person that's on the face of the issued patent, the name there. That's the primary examiner. Then I became a supervisor, and actually first I was a trainer in our academy, training new examiners, which was a lot of fun. It's great having people come in the door and being excited about a new job. And then I became a supervisor, so I would supervise examiners. And then a couple years ago, I actually got an opportunity to work in the front office at the USPTO, which is the office of the director and the Undersecretary of Commerce for Intellectual Property. At the time, the director was Director Kapos, and he has since left and is actually working here in New York City now in a law firm. But I worked for the Deputy Director, Terry Ray, who is now the acting director. And that was a very eye-opening experience for examiner, examiner, supervisor. You're very siloed in the PTO. You have your job, you do your job. And to be at the front office and to understand what goes on at that level, it was a very eye-opening experience, and I got a lot of exposure to the different activities that are happening, the different initiatives. When I was there, they signed the new law into play, the American Invents Act. So I was there, and they were writing the law, they're writing the rules according to the law. So it was it was an amazing experience. And then through that, I found out about our new initiative, which is outreach in New York City, and so I applied. So this was just an idea. The American Invents Act created satellite offices. So we have a satellite office in Detroit. Before that, our only office is in Alexandria, Virginia, but Congress was like, you need to get out there, you need to educate, you need to be in different places, and we need to be able to recruit people. And moving people, not everybody wants to move to Virginia, so it became hard for us to recruit high-quality engineers for our jobs. So we have our satellite office in Detroit. We're going to have one in Silicon Valley, one in Denver, and one in Texas. But our director thought, wow, maybe we should think more about what we can do with this outreach. And he saw an article in the Newsweek, I think it was, about the Roosevelt Island project for Cornell Tech. And Some of you may be aware the mayor had this Applied Sciences Initiative and Cornell Tech won. Their academic partner is Technion in Israel, and they're going to actually build a 21st century campus on Roosevelt Island. So it's a very exciting thing there. I mean, it's obviously a very long-term goal. They're going to break ground next year, and then hopefully have a building open in 2017, I think the plan. But in the interim, they've actually started having classes. They had their first class of 7 students in January, and they're going to have another class of 25 in the fall. So I'm working out of their space as part of this partnership agreement. And my role here is obviously to be at Cornell Tech, answer questions if they come up, but my main focus has been very much outreach and education to the community. I've been connecting with all the different universities in the area, all the different groups. I've had I've been a lot of activity in the tech space because there's so much going on in New York City and the tech startup scene right now with software. And of course, some of you may have heard the controversy surrounding software patents and patent trolls. So, interacting with those people, educating those people on the system is how we make it ultimately, hopefully can make it better. And done a lot of work in the bio space as well, life sciences, because there's tons of hospitals and university hospitals in the area, and connecting with those people, because a lot of invention comes out of universities, and we're trying to find a way to accelerate commercialization of that invention. But I think my role has been very much just educating people, and so I actually did at least a couple talks out on Long Island, one into an inventor group. I think that the inventors, you guys need them a lot of education, because you don't know, you get this great idea and you just don't know what to do with it. It's like
You're not calling them
no,
uneducated. You're
no,
saying that
I mean
you
in the
understand
process. I mean, everybody I talk to needs education in the process, whether they're work for a university or they're an independent inventor. It's like, it doesn't matter. The more you understand the process, the better result you're going to get. And that's what I'm trying to do here. We actually have a very large office of innovation development at the PTO, and they're very much about connecting to the independent inventors. But it's like getting around the country. It's just it takes a lot. So I'm here on the ground. I'm a resource to anybody who has questions about USPTO. So that's kind of what I'm doing here. And actually, at the end, I'll have a link to my website that actually tracks everything, everywhere I've been, everybody I've talked to, and actually has all my presentations I've given, because I want to be very transparent about what I'm doing, how I'm engaging with people, and obviously looking for feedback about how I can better engage with people and how I can be more of assistance. So I'm just going to do very quickly high-level overview of intellectual property, just because the USPTO, most of us think, my experience is patents. I know patents. But there's also, design patents can be very important to inventors. For patents, you have opportunities for provisional applications. There's no such things for design patents. That's an important thing to understand. And of course, and I'll talk more about provisionals in a bit, but provisionals are not examined. So, people call them provisional patents. It's provisional patent applications, because they're never going to be a patent. You have to do something with provisional to make it a patent. The other things we deal with the office is trademarks. And if you're looking to launch a business, branding and trademarks can be very important. And so the one thing about trademarks that I'll mention is that trademarks, while you can register your trademarks with the USPTO and you get the protection, you don't need that sort of registration in order to have a trademark. There is common law associated with trademarks, so as long as it's in use and it's your mark. The important thing to understand, though, if it infringes on somebody else's mark, there might be a problem. And if by registering it with the PTO, you have an assurance that it's not going to be infringing, because they're not going to issue a mark that is infringing on somebody else's mark. Another thing about trademarks is, I'm trying to think. Am I not talking loud enough?
No, I could hear you fine, I just couldn't see it.
Can everyone hear Sue okay?
No, so-
Okay, why don't we go with them? Come on.
And I talk really fast, I'm sorry. I think I was from New York, but I'm really not. Huh?
Oh, they were getting some technical commands here. Is this blocking you, Steve?
It's a problem.
Okay. So Sue's gonna speak up a little, right?
I'm trying.
Okay.
And I do talk really fast, so I'm sorry. Let's see, so I'm trying to think if there's something else about trademarks. Okay, copyrights. As the USPTO, we actually represent the administration on copyright issues, so we actually have a division of our office that deals with copyright policy. And not a lot of people know about that for the USPTO. But I think copyright's just much like the trademarks, it's you don't have to register it to get the protection. Once you created that artistic work, it is a copyright. But registering it, just like a trademark, there are advantages. And one actually, and I didn't mention the advantage of registering a trademark, if you're actually looking to, if you've created a product, it's become, and some people are starting to copy your product and actually bring it into the country because they're manufacturing it somewhere else. If you register your copyright, your trademark with the borders of custom authorities, they can actually block those imported items from coming into the US. And that's also true with the patent. So those are things like when you're at the point where you're making success and you're getting somebody copying your work, it's like, that means you've made it, right? Okay.
Sue, a
Yeah.
question about that, because an attorney, and Louis, you might want to mention this, if you are registered with your trademark and copyright, you have greater recourse in terms of the damages you can take from an infringer.
Yes.
But if you're not registered, you don't have. You can stop them, but you don't have as higher recourse.
No money.
No money.
So register.
No register, no money.
Yes, sometimes it's a balancing act. You got to figure out what makes the most sense for you. If you're looking for money, register. But you got to pay the money to register. That's
Is it a separate application for outside of the border?
Huh?
A separate application, the border is that?
Yeah, well, once you have your issued patent or trademark, you just would register it with, or file it with the Customs Border Protection. And then they could stop things from being imported into the country. I mean, they do the best job they can, considering all the imports. Sometimes it can be very challenging, but they do deal with that.
Sue,
Yeah.
excuse me, one question. On that chart that you showed, and this is an interesting situation, you indicated trade secrets.
Oh, yes.
Trade secrets, though, are not something that you can register with the patent office, correct?
No, and I think I talk a little bit more about trade secrets. And I'm not really good at this. I talk a little bit more about trade secrets, but trade secrets, it's about knowing what makes the most sense for your invention, your idea. Trade secrets have it's actually common law protection, again, and you can get damages, not as much as you would get with patents, by no means, but you can get damages. But trade secrets, I mean, if your invention can be reverse engineered, I mean, trade secret's not going to get you anywhere. And you need to actually actively protect your secret. But if you're creating a business, things like your business plan or your customer list or things like that, those can actually be trade secrets. And if you actively protect them, if somebody steals them as they're, exiting the company, you have a recourse. So it's good to know about trade secrets.
You mentioned a few minutes ago about that there's a branch of the government that protects imports from coming in.
The customs.
Now, this to me and my clients is a big deal because everyone says, what's the value of a patent if somebody's gonna just knock me off and flood the market with a product that's just like mine? You're saying that there's actually a division of the government that would help you?
It's the Customs and Border Protection.
Customs and Border Protection.
Yeah,
Do
and
they do much?
They're actually, so Gordon, here's an example, and it's like most things, you have to be somewhat active about it. So we had produced some product for a client, and it involved using a Budweiser logo and also a logo for Russell Simmons' company, Fat Farm, if any of you are familiar with that. And we had labeled our boxes, and we were authorized to do this. Budweiser, they were like light up ice cubes, and Fat Farm ice cubes. So apparently, Customs was on alert for people bringing in counterfeit Fat Farm merchandise. They froze our merchandise. They ostensibly said it was because we were violating some other regulation, but they were just piling on because at the end of the day, it was about the trademark. And until we were able to present a letter to U.S. Customs and Border Protection with a letter of authorization, they weren't going to release the goods.
Yeah.
So they will. So you have to register and let them know that you want your trademark on a watch list. And if it shows up on any declarations, they're going to freeze it immediately.
Yeah.
Same, but with patents, you have to tell the Customs and Border Protection people that you feel there's somebody bringing stuff in, and if you know who they are, they will freeze their shipments if you show that you have a patent issued.
Yeah, and I think each importer has like a number that's associated with their import, so it's a matter of identifying who's bringing it in, and then you can find out the number, or they can find out the number and then deal with it.
Excuse me, what about knockoffs within the US? For example, there's Spanx, there's a patent, there's a million knockoffs. Should she be a patent, or should she just focus on it?
Well, I would say that it depends. I mean, I would say that in the apparel industry, patents are actually it's really hard in that industry. I think that one individual I never actually met her, but I know she came to talk to the PTO, and she presented at World IP Day recently here in New York City, Yummy Tummy, and she has a patent on one of her designs on her outfits, and there was a whole lawsuit with Spanx, and they were, I guess, I don't know what's going on there, but I think that in the apparel, I know that she has actually had success with respect to enforcing her patents. So there are, I think that with respect to apparel, it gets really hard because it's such a nuanced thing. When you're talking about, a patent's a drawing, and when you're associating it with actual apparel, it's like, it's hard to kind of associate them in that way, because you have a drawing and then you have an actual apparel that looks the same, but maybe when you get in the minutia, it gets harder. So I would say that it's not always appropriate to get a patent, especially in that sort of industry. And the marketing, the trademark, or some other thing can be much more important than getting a patent. But you have to be aware if you're potentially infringing on somebody else's patent. I mean, that could be an issue as well.
There's a classic story with a lot of knockoffs where, people in China, they've just taken stuff that they think is great and they've reproduced it with the logos on it too. Not just the idea, but the logo. That's stupid. There might be ways to, I'm not advocating it, but do a knockoff without infringing someone.
Yeah.
But if they didn't have a patent, but if you put their logo on your product, then that's kind of goofy. There's a gentleman here who looks at that.
How does the shadow patent like? I've heard about the term shadow patenting, like you have a patent and somebody else comes in, files a similar patent, and produce their product elsewhere. Like, how can you avoid that?
Like in a different country?
Yeah.
Well, I guess the big thing about patents is they are not, they're U.S. patents are only U.S. patents. You have no right to enforce a U.S. patent anywhere else in the world. So that's, they're territorial in that, if you have to go to a different country, you need to get a patent in that country. And there are mechanisms to kind of get expensive mechanisms of getting patents around the world. I mean, you have to literally go in each country to do it. And you can imagine how kind of lawyer's fees you're talking about there. So I would say that, at some point, there's not much you can do unless you have the money to do it. And, and then you have to go, and some countries are better at enforcing than others. And I would say the U.S. is probably the best at enforcement. China, one of the worst. I mean, that's the thing. It's like there's very disparaging as far as how each country does things. So you have to think about what makes most sense to you. Where are you going to make the profit? And maybe if you are manufacturing in China, you do want to file for a patent in China. That way you can, eventually sell it there. Or, but you have to. But then you have to think about the filing date and when you're filing these applications. So there's a lot of. That's why we always recommend getting an attorney or talking to an attorney.
The gentleman who had a question.
Yeah.
For
Yes, as far as two questions I have. One is the foreign patent. I just read something about a Paris Convention or something that some countries are interchangeable?
Well, it's not really, basically, and I have it a little bit later in my slides, so basically if you file a provisional application with the USPTO, you can, that's like a placeholder at the USPTO, and hopefully you will decide to transition it into a non-provisional application. But during that time, when you file the provisional, you also can consider filing it in other places, getting priority to that provisional application. And that's what the Paris Convention's about. And then we also have the Patent Cooperation Treaty,
Right.
which is another mechanism where you file a provisional application with USPTO, and then you can file a PCT, and that gives you like 18 months to think about if you want to file it in different countries. So that gives you a lot more time, but it's an expensive process.
And the next thing is, I just read up that they're gonna have pro bono patent attorneys or something set up in different areas or something?
Yeah, we actually have started that. I've trying to get it going here in New York. Haven't been successful yet, but hopefully before I leave. We have it. We have a central depository on our USPTO website where you can actually register to do. And there's qualifications typically. You know, you have to have meet income requirements, that sort of thing. But they will hopefully identify a pro bono attorney who worked for you pro bono. That being said, here in New York City, we do have, Fordham Law School does have a clinic that does pro bono work. And so I've actually referred a couple people to the clinic, and at least one of them I know got picked up by the clinic. And they also have a vetting process.
I mean, because that sounds great, but not to give people false expectations. Do you have a sense of what some of those parameters are for getting the pro bono support?
I honestly don't know. I mean,
Is it on the website?
It might not be on our website, but it would be linked through our website. On our Office of Innovation Development for Independent Inventors, there's actually a pro bono link that actually goes there, and so you would submit some information, and then they would contact you. And it's based on income. So if in a New York City area, I would say that considering the cost of living here, the income would be higher than other parts of the country. So, but I don't know what it is off the top of my head.
So we should go through some more of the slides, and some of the questions will be answered. But there'll be plenty of time for Q&A at the end also.
Okay, so patent. We talked a little bit about a patent is really a right to exclude others from making, using, offering for sale, or importing the claimed invention. The patent is a limited term and it's territorial. Oh, we talked about all that. So only in a territory, so there's no worldwide patent. I will share with you, the office has been very active in talking with other countries about more harmonization efforts. So, maybe 10, 20 years from now, we'll have a harmonized patent system. All right, and the idea behind the patent system is that it's a quid pro quo. We want inventors to disclose their information so that people will ultimately, learn from it and hopefully invent more things. And so it's kind of like we give you a limited right, a limited time monopoly, and you give us the information so that we can release it to the public and everybody can benefit from it. So protecting inventions, encouraging inventions and innovation, promoting commercialization, application of the invention, and acceleration of commercialization to the whole society. So, why do you want to get a patent? Now, I would say that it's really up to what you're doing. I work for the USPTO, but we're not necessarily looking for more applications. We got plenty. Although, if you have something great, we want it. So, but it's, it can be used to gain entry to a market, in a market that I would say that if you have this wonderful idea in this, I don't know, I'm trying to think of something, a new type of cell phone. How are you going to get into that market? The only way you could ever get in that market is if you can patent your invention, and then you can get, either get the money and start a company and do it yourself, or get the patent your invention and then maybe sell it to one of these big cell phone companies, or license it, or something like that, because you don't have the capital to get in these industries. So, but if you come up with a great idea, you need to be able to find a way to get into these industries, and that's what a patent can do. Excluding others from the market, I think that Apple, Samsung is a good example. Apple sued Samsung because they saw a little decline in their profit share and their market share, and they're like, this isn't good, what's going on here? And, you know, looking at their patent portfolio, they realize, oh, this is what's going on here. And a lot of those patents in that case were actually design patents. So I would say the design patents, that case is evidence that design patents can be very important and very useful to inventors. Using as a marketing tool, if you're trying to, you know, if you're looking to start a business, looking for funding, you could, you know, I have intellectual property on this, and that makes venture capitalists like, oh, okay, you know, maybe there's something here. They have it protected, and of course you can sell or license it like any other type of property. So, role of the patent examiner. Issuing valid patents. The examiners are, I'll kind of give you an idea of what the examiner goes through every day. Everything is on the computer now. When I started the office, we actually had paper files, but all that's transitioned onto the computer. So the examiner will pull up a case, review the specification, look at the claims, and then find some prior art, and then usually send out a rejection. Let's just face it, that's what they do. We train them to reject. But the reason we train them to reject is that we're looking to make sure that the inventor, we want them to get their patent, but we want to make sure that they only get what they deserve, because otherwise, this is a property right. So you can exclude others from this marketplace. If this patent's too broad, you can potentially exclude others. And you know, I know people have probably heard stories about overly broad patents, and they exist. So we need to we train our examiners about, you know, to reject cases, partly because we need to make sure that they are doing a good job finding prior art, searching it. But we also want our examiners to find allowable subject matter. And we really do, you know, look at the specification. When you're talking to the attorney, ask questions, try to figure out what's going on so that you can find allowable subject matter. And of course, advocate for the public. The prosecution should not be adversarial. However, you know, when you've got an attorney and an examiner, sometimes it gets a little adversarial. But, you know, we really have been very proactive in engaging more, doing more examiner interviews with attorneys. As an examiner, I actually had interviews with attorneys a lot of time, but every once in a while I would also have an interview with inventors, which I thought was great. I loved having interviews with inventors because to actually hear from the person who created the product. I think that's where you really learn what's going on, because at the PTO we hire engineers, but you know, we're not necessarily inventors, and we're certainly not we're not experts in the field that we're examining. We're knowledgeable, we can get it, we understand what's going on, but we're not experts. So to talk to the expert is always very educational. So talking to the inventor. I actually had one time where an inventor, he was working on a case pro se, which means he was prosecuting the application himself instead of having an attorney, and he came to my office and demonstrated his invention on the floor. It was a carpet seaming device. And you know, I had sent him a rejection, and after seeing it and how it worked, I'm like, oh, that rejection was bad. I mean, it was kind of like, okay, now I understand. Seeing it, how it worked, how it functioned, it was very educational. And I think that having that interaction can be useful. It doesn't always happen. It certainly doesn't happen in a majority of the cases, but when it does happen, it's, you know, it's very educational for our examiners.
So you're saying that the bias at the office is to reject, but just because you got a rejection and you are receptive to people countering the rejection, it doesn't mean that it's easy to get an allowance.
Yeah, I would say the bias at the office is to actually grant valid patents. However, I would say that in order to grant valid patents, we need to do a very good job at teaching our examiners how to reject non-valid patents. So I would say that so much of the training of our examiners goes into rejection. It's very easy to get into that rejection mode. So as a supervisor, I would always be like, did you see any allowable subject matter? What do you think about this? What do you think about that? To try to push them to think about how can a case be allowed. That's a big thing. Yeah.
There's a sense sometimes that big companies have an easier time getting things patented. I've seen cases where Avaya has patented an average and somebody patents a rounded corner. Is there a sensitivity in the PTO that says, you know, big companies get treated differently, or that they are kind of aware that that happens and people try to counter that, or is there a sense of it anyway?
Yeah, I would say that any case is this pretty much the same for an examiner, whether a big company, a small company. I think the big difference is when, you know, I mentioned pro se inventors. Those are treated differently because the examiner tries to hopefully be more of assistance to those pro se inventors. The guy that came in and demonstrated the product on my office, he had an attorney write his application, which I think was a humongous step in the right direction, because I've seen pro se inventors where they wrote the application themselves, and it can be, you know, it's so when you're used to seeing, because so many of our filings are from big companies, from universities, when you're used to seeing these well-written applications and stuff like that, and you all of a sudden have something that's kind of crappy and you're trying to figure out what's going on, I'd say that it's natural that potentially that person would be treated slightly differently, but it's still, we with pro se inventors, we really try to be more helpful and educate them on the process as much as possible. And we have an Office of Innovation Development that actually engages very much with the inventor community.
And if you happen to draw an examiner who just really isn't getting it and you're having a difficult time, is there a process which you can peel or switch laterally?
The process to like switch laterally is actually kind of complicated, but we do have an ombudsman program that can help with assistances where there's potentially problems with the examiner, or there's issues with other type of issues with the case. So we do have a program that can be of assistance in those type of situations.
But you do have a process where the attorney and the inventor, even a pro se, you can ask for a conference with the examiner and a supervisor?
Oh, yeah. You can have an interview, you can request an interview at any time with our examiner and a supervisor. If the examiner, and it has happened, declines, then, you know, call the supervisor and talk to them, and they're more than likely going to be more receptive to having an interview.
We had a situation with a client where they had a rejection. They asked for their attorney asked for a conference with the examiner and the supervisor, and the supervisor basically gave a very polite dressing down of the examiner because she overreached in the rejection and it was allowable subject matter. So the lateral, as Sue saying, could be complicated, but
Going up the chain
is not.
Yeah, and I know that some people are afraid to kind of go up the chain, but it shouldn't be something that's afraid. The examiners are not going to hold a grudge. I mean, this is just a job to them. They're just looking to make a paycheck. So
They don't work in the post office.
No, they don't work in the post office.
We have another question?
Yeah.
Yeah.
Missed question. I had heard this is, I think average time is 20 months to patent process or something.
It varies.
Okay.
Yeah.
Somebody said for a senior citizen, it could be faster than somebody younger.
We do have different mechanisms of fast tracking applications, and one of them is actually age. Yes. So that's just one of them. There's other methods of fast tracking, but yeah, that is.
So you should
one.
have your grandfather file your patent for you?
Well, if they're not the inventor, then that's a problem, because only
Wink, wink,
inventors
nod, nod.
can file patents.
Oh.
Yeah.
What are the other methods of fast tracking?
Of what?
Fast tracking.
Well, you can pay us more money. That's one way to do it. We had a green tech pilot, which I think is expired. I'm trying to think if there's another one now. Those two might be the only ones right now. I think it might be illness as well as age, actually. So, you know, if you're gravely ill, but I mean, that's not something you would want to be. So, but if you pay more money, then we will accelerate. Yeah.
I was just wondering, so if you don't have a patent, anybody can just steal your invention? Because what if you don't know if your invention will make it anywhere? I mean, so you don't want to get a patent right away, but then you invent it, and then once it starts getting somewhere, then someone else grabs it, and then they make a patent on it.
Well, okay, so if you can actually prove that they stole it from you, there's ways of getting around that. But we've just transitioned to a first to file system, so even before you go out there and think about making it somewhere, you need to think about filing a provisional application at the very least, which it actually, I think I have the fees for provisional. It's actually, getting it written and with attorney fees can be expensive, but actually filing with the PTO is not too bad, fee-wise. But if you're going out there with invention, you need to have something in front of the PTO already, because once you've been out there, if you sold it, if you know, you have no rights to patent it at that point.
So how much protection is there with a provisional? Is it just a time stamp?
It's just a timestamp, and it really doesn't allow protection, but it gives you time to think about what you want to do next. Like, what is the next step? And, you know, you can actually file multiple provisionals. Say, you know, you don't do anything with that first one. If you haven't gone out and sold it or disclosed it, you can still file a provisional on it. So it just gets you a foot in the door at the PTO.
Yes.
Just to refer back to the fast track, I read on the USPTO website that there's certain inventions that will get fast track, like for like alternative energy and things like that.
Yeah, that was a green tech pilot, but I think that actually has expired, but I'm not 100% sure about that. I can't think of any other fast track. I think the only one that I know of right now is for pay more money.
How much more?
I have to look into that.
Sorry, I just want to go back to the provisional. Once you file the provisional, can you sell the product and see how it's on for the next year? You get 12 months for that?
I mean, once you file the provisional, you have a foot in the door, so you have a year to just do whatever you want to do with
But
it.
even if you start selling it, and you see how it's selling, and then you just sign it?
And I'll go into a little bit more of that, but you need to be very careful about everything. All the information is in the provisional. Like if you file a provisional one-page drawing or something like that, it really doesn't sufficiently describe what you've created, then you're not going to have that protection. So
Can
you
I
need
file an additional provisional for that?
Well, yeah, but you would get that second provisional date, not the first one.
Are you going to have a slide about provisional
Yes.
too? No, there's a lot of good reason to cover provisional because there's a lot of myths that people associate with provisionals, and like as Sue said before, they don't get examined if you don't file an actual utility
No,
patent.
yeah.
But if you do file a utility patent, they will go back and look at it. So but we'll get to that.
Okay. So I just laid out the laws. These are the laws that our examiners consider when they're examining an application. 101 is, you know, what's eligible to be patented. And there's been a lot of activity in that area in the biospace. I don't know if you've heard about, you know, genes can't be patented. That was actually a recent decision by the Supreme Court. The USPTO has been granting those patents for 20 years, waiting for the courts to give us guidance on this. You know, 20 years later, we have some guidance. 102 is about it must be new, so nobody's done it before. 103, it must be non-obvious, and I would say the majority of the examiner's time is spent on what's obvious and what's not obvious. I mean, as you can imagine, it's like, as an examiner, it's like you see one thing here, you see one thing there. It makes sense to put it together, but they've also just read your specification. So we have a really hard time training examiners on this issue, and it's one of the more challenging areas of the law. And then 112 is about sufficient disclosure and enablement, and that has to be. And actually, I'll mention this right here. 112, if you file a provisional application, you don't have to worry about 102, 103, those you don't have to worry about. You need to worry about 112, because 112 is about sufficiency of the disclosure. So if you're filing a provisional application, you need to make sure that there's enough information in there that your product is sufficiently described.
Lady in the back of the room.
When we're doing a prior art search and a patent search, they have the same files that we have access to at the USPTO. The examiners, are they they're on the same system that we have access to? Or
What system are you talking about? Because we have other systems at the PTO.
well, I've done patent searches, actually legal patent searches, and then I've gone to the USPTO.
Okay, so you've done searches at the USPTO.
Right.
So what the examiner has is very similar to what is at the PTO. So that east and west, those tools are actually what the examiner uses.
It's always the language though, because that's really what is a independent inventor, you don't know the inside language.
That's why the two gentlemen in the back of the room are standing there.
You know, I actually say that.
So I wasn't saying that facetiously. You know, a good patent attorney helps you really translate that language and understand what to search and how to read existing claims, because they are confusing.
And I'll mention this too, because the USPTO, we actually, you know, we have our Office of Innovation Development. We have an Inventor Help Center that's actually staffed by former supervisors who've retired and who can answer a lot of questions potentially about searching and all this about stuff. We have those sort of resources available for people. And it's just an awareness factor, so that, letting people know that they're there and that they should try to tap into those resources.
How do you fund that?
Where is that?
It's at, I can pull up the website in a bit, but it's just USPTO, Office of Innovation Development. There's a tab for inventors, and then I think there's like Get Help or something like that.
Okay.
But everything is on the USPTO website. It frustrates me because there's so much information and it's not as well organized as it needs to be, but it's all on there.
Lance, you had a question?
I realize you guys are a business. I realize he's got a business. When you're actually making prototypes, you're in that level, it will usurp every last dollar you have. So the subdued commercials about pass more money and stuff like that, for the everyday inventor, it's not happening. It's not happening. So, we're all here because we want to get out of the box. I can't even afford to go to you. I mean, we want to get out, and I've got things that have been sitting on my desk 10 years. It's really extraordinarily difficult for us to hear more fees, get the patent attorney. Of course, every one of us wants to get the patent attorney. Unless you got a big company behind you, you're not going to be able to afford the $300 an hour.
And I'm very much about educating the inventor on the process so that they can do it themselves. Like I said, the guy got his patent that came to me and he was doing it himself.
When you blew it for me, when you said pay us more money and you get streamlined, I almost want to walk out.
I know.
I almost want to walk out.
I'm curious, did everyone else feel it was like the patent office is asking for more money, and maybe it's an option that the patent office does provide?
That was actually part of the that was part of the legislation.
It ain't fair.
I agree. It's not fair, but it was part of the legislation that was passed by Congress, and we have to do what Congress tells us to do.
So very few are confusing. I don't feel so bad. There's a handful, and I tell you, out of all the clients at this firm, there's maybe 3 that will use the expedited process, and they don't use it for everything. So it is a very particular, it's a scalp. It is not the regular way you're prosecuting patent. You're in line with the IBMs and the Googles and everybody else. It's just for the very particular ones that they feel they need to get out quickly, the fees are astronomical compared to what they are if you regularly file it 4 to 5 times a large company. So they don't even use it. So don't feel so bad that they're really taking it from you. They're actually trying to extract it out of business.
And what we're really trying to do is, we're trying to get our backlog down so that every application can be fast-tracked in that way, and there's no additional money required. The part of the problem the PTO is facing is our backlog, and we're trying, so we've made a lot of effort, we made a lot of progress in that backlog, and when we get it down to the point we want to get it down to, hopefully with sequestration it might take a little longer, but when we get it down to that point, every case will be fast-tracked, and that's what our ideal is.
In the back?
Can you elaborate on USC 103 plus the non-obvious explanation? I've heard that spoken about a few times and sort of needs to be fixed, and sort of touched on it for a little bit, but I'd like to hear maybe a little bit more drawn out.
Yeah, so basically when you're filing your invention with the office, the examiner will do a prior art search. So what they'll do is they'll potentially find, your invention is ABC. They'll find AB, and then they'll find C somewhere else. And so their typical thing is, it would be obvious. So they have to explain why it's obvious. And so that's what that is about. And sometimes that can be, obviously they've already obvious, I hate that word. They've looked at your specification, they've read what you've done, so to their mind, well, it's obvious, but they can't rely on what you disclosed. They actually have to find another reason why. So whether it's from reference in themselves, whether it's from the knowledge of one of ordinary skill. So that's part of the reason. That's part of the training that we give our examiners on different ways to find that sort of guidance. And there's actually been a case law from the Supreme Court that has actually detailed different criteria for finding obviousness. So we always love those.
So I've heard from a few attorneys that they tell their clients, and everyone should know about this, that your failures are as important as what your specification is when we do have an appeal to a rejection, because it proves non-obviousness that you had 27 failures before you came up with a specification that did work. So to be able to document some of those failures for an examiner might help demonstrate non-obviousness.
There's that. There's also long felt need. Somehow, you've succeeded where other people have failed, or no one else has thought of this sort of thing. There's also commercial success. Can be actual, if you've achieved, and that's a hard one to show, but if you've achieved commercial success, then you could potentially overcome an obvious type rejection.
Do you have a follow-up to that?
A lot more on that, but real briefly on the commercial success. So that's the first time I've actually really heard that. So would a crowdfunding campaign potentially be an example?
I would actually probably not. But it doesn't mean that you can't. I mean, at the point where you're a crowdfunding campaign, you probably aren't very far through the office. So maybe later on potentially you could have. I mean, it would have to be pretty.
And a
dramatic.
crowdfunding campaign, if you had a goal of $50,000 and you went to $100,000, that's successful, but does it show mass resounding commercial success?
Exactly. Is there like a number that's tied to?
No, there's not. It's very wishy-washy, and I know there's been at least a couple of instances of the PTO, but it's very uncommon.
We've had quite a few speakers over the years who recommend not filing. A lot of novelty items, a lot of marketing companies. We had a woman from HSN, and I spoke to them, and they're just like, forget the patent, it'll drive you crazy. Just go out, make it. Like, it depends. Obviously, technology is an area that you need a patent. But what areas would you recommend, even though you're probably not supposed to recommend it at all?
We're not looking for more applications.
Would you say it's like futile to file a patent?
I would say that there are areas that it's not necessarily worth it, because you have to invest a lot of money and resources into doing it. And if you do it and you never, that money and resources potentially do in marketing or, another sort of getting your product out there. So it's not always useful to do it. That being said, it gives you protection where if you are successful, potentially if you have no protection, then somebody can steal your product. So, I mean, there's a balancing act. I wouldn't say that you would, I just don't know. I don't know.
The choice to patent is really a business strategy. You have to think about how do you allocate your resources, what's the benefit. Certain types of products, like what you're saying, novelty, if it's a fast life cycle product where you're in and out of the market within 3 years and your patent might not even be examined or you're still fighting it, right, really it might not be worth it. If there's a deterrent factor, it may be worth it. But just because you have the deterrent, it doesn't mean somebody isn't going to infringe.
Yeah, and also if somebody's ripping you off, they're already doing pretty well.
Exactly.
And then you'll be able to hire.
Well,
that's how I see it.
I mean,
if you reach that point.
Yeah.
It's your copy that does success.
I mean, you can have the provisional application gives you the right to say patent pending, even if you decide you want to do a non-provisional. I mean, you have that right. So, it can kind of ward off potentially infringers just by doing that.
Yes?
Yeah, so how about a patent agent? Is that like a paralegal is to an attorney, patent agent / to a patent attorney?
Patent agents are actually just, if I left the PTO, well, I have my law degree, but I'd be a patent agent. So sometimes they're former examiners and they've been, they take the patent agent's exam. They have knowledge, they can prosecute before the USPTO, but they just can't, go further with it, so they can't go to court, that sort of thing. It's only PTO. So it's actually, patent agents can be more economical than attorneys and have the same knowledge that you would need
You can get, I think they said patent attorney for the patent agent for the search, but a patent attorney for the actual patent.
Well, the patent agent can do everything in front of the PTO. So they can prosecute the application with the examiner. You don't need to be an attorney to do that. You just have to if you're not an attorney, even for an attorney, they have to be an agent as well. They have to have that patent registration number, and that's what the agent has to prosecute before the PTO. Okay. So that puts them on the same par at the PTO, but the attorney can do more than an agent can do outside of the PTO. But at the PTO,
You mean outside of PTO?
well, like if you're looking to license or that sort of thing, if you're
Contracts and things.
yeah, I mean they're
As far as the
attorneys.
actual patent, you could save money just going to a patent
If you can find a good patent agent, and there are a lot of good ones out there, that's definitely a
How
way
do I
to.
find, I guess, same old.
Well, the USPTO has a listing of all the registered patent
Yeah.
agents, so we can't make recommendations about attorneys or agents, but we do have a listing of all that.
Question?
Well, are there lists of resources for prior art other than the obvious, Google it kind of thing?
I don't know.
So how do you guys do that search?
Well, we have a system at the PTO that was it's built for the examiner search, and they use a Boolean search terminology. We have class and subclass searching. It's a really quick, very fast system for our examiners because they have a very limited amount of time to do their job. So we need to make sure that they have all the information.
To that point, Sue, do foreign patents count as prior art to preclude a U.S. patent from being filed? And do you guys have access to that?
Yes, we have access to all the foreign patents, pretty
But
much.
we don't in the USPTO.
Actually, Google Patents has most foreign patents these days, so it is out there. And actually, there's a couple of, Espasnet in Europe is actually a really good site for finding foreign patents as well.
That source that your folks use, is that public facing?
It's actually not,
Okay.
except for we do have search terminals at the USPTO in Alexandria.
You have to go to Virginia.
But the Civil Library here has a search terminal that you can use, so there is one here. And when we open in Roosevelt Island, the idea is to maybe have more there.
So in a product that's commercially available but not patented overseas would also preclude somebody from getting a U.S. patent, right?
Yeah, anything that's out there. So basically, the examiner, they look at your filing date, and anything that's before your filing date is potential prior art.
Lance?
So, I'm a little confused. At the top, you said you would have to go to those other countries and get your patent there to ensure that your patent isn't going to get breached in that country. However, if I'm following you correctly, the USPTO has access to all foreign patents.
Yes.
So can you do your search of that patent worldwide through the USPTO?
I don't necessarily know if I understand.
Well, okay, I got a gadget, and it's good to go here in the States, but it's not good for China. In order to get it registered in China, I gotta go to China. But from what I thought I just heard, is that you guys have access to all foreign patents.
Yes. So if that
Why
is.
wouldn't I just go to you and say, is it in China also?
Well, I mean, basically what our examiners would do is they would search all foreign patents. If they came up with a Chinese patent, they would cite it as prior art. But we're focused, but I would say that our examiners rely almost solely on US patents because so many people file here in the US. There is a new search feature for actually Chinese patents that is available on our USPTO website, where you can actually search Chinese patents. So
Only China, no other foreign databases?
I don't know if there's other foreign databases. I think this is a special thing between us and China to make their prior art available to our examiners, because right now China is the world leader
And
in
again,
filing of
that's just to do your
applications.
search.
That's just to do your
You
search.
would actually physically have to go over there and secure it there in their system.
Yes.
Okay.
Okay.
Well, now I have two questions. One, so what is the current turnaround once you file a patent, both for the fast track and the regular?
Well, the fast track is anywhere between, is less than a year. That's the whole thing for the fast track. For the regular, it depends on the technology, and some technologies are much faster than others. I would say the faster technologies are actually mechanical technologies. Our biggest backlog is in high-tech areas. So I don't know, maybe 20 months to like get a patent, but it could be more or less. Like
Dave and Louis, does that jive with what you're seeing?
It depends.
Is that maybe like 3 years?
No, I'm talking about, so I'm saying something filed today. Something filed 2 or 3 years ago, yes. That is, literally.
You're saying it's getting better.
It's getting better is what I'm trying to say. It's getting better. I don't have the graph, but we have showing that cases filed today, picking up at 15 months.
Awesome.
So, I mean.
So it was picking up in 15 months.
Yes.
Right, so we tell clients 3 years. 3 years from the time that you.
For the whole process.
Are you sandbagging, Dave?
No, 3 years, we say 3 years.
Is that utility
Now,
and
picking
design?
up, does that mean you get your first response?
Yes.
Okay.
Is that utility and design are the same amount of time?
Design is actually quite less. It's a lot less. I'm not sure what the amount of time for design is, but it's a lot less. We actually, for the first time in a long time, we've actually hired design examiners though, because we've gotten a lot more filings in the design area. But hopefully we'll not have the same situation in that area that we've had in utilities.
You haven't asked a question. Go.
And these numbers are based off the date that you file your non-provisional patent?
Yes. Yeah, it's based off the non-provisional filing. And it really depends on the technology. The more high-tech, the more bio-life sciences, those take longer. The mechanical technologies, our examiners churn through those very quickly because they don't have a lot of time to do them, so they get through them very quickly.
So when you file your, all the various fees, what percentage of your cost is that? Or is it basically government is still putting money into it, or is it pay 110% or 80%, or how much of this is self-funding?
It's all self-funded. USPTO has been self-funding since 1992, I think. We've had fees diverted from us to other areas, but we are completely self-funded.
Gentleman in the back.
So, matter of public policy, was there any debate in Congress, the subcommittee levels, where the legislation for patent reform was promulgated? Was there any discussion about giving tax incentives, like investment tax credits for small company investors or individual inventors?
Honestly, I don't know. Yeah.
Do you have a personal opinion about that? That maybe small inventors promote innovation?
I mean, we
should be given an advantage over big companies.
Congress did, I think it was 1999, asked us to engage with more independent inventors more directly, and that's how our Office of Innovation Development came about. So as far as incentives, I don't necessarily, that's way above my pay grade.
So can you comment about the micro entity?
Yeah, I actually do have a slide on the microentity on how much it costs, but one thing that came out of the American Invents Act, which was passed in 2011, was a microentity fees. So that is actually, our fees are, if you filed an application, you're familiar with small entity because you just a company less than 500, you qualify as a small entity. But now we have a microentity. So if there's certain criteria, and I think I have a slide on that. And by the way, all these slides will be up on my website later on. So so if you don't catch something, don't worry, it'll be there. But the microentity fee is 25%, so it's half of what the small entity is. So for a provisional application, I think it's $25 to file a provisional application with the USPTO. So it's cheap to file a provisional application with the USPTO to qualify as a microentity. And the criteria are, if you have less than 4 patents, and I think there's an income level, which I think I calculated out to be at like $150,000, $160,000 a year. So, I probably qualify for that. So, it's not like an absurd, really low income. So, and then I'm trying to think of what else criteria. But those are the big 2 things that I remember. Provisional will, I'll have some slides on it, but it's a 12 months is how long it lasts. All right, so we're gonna talk, it's all about the claims. So one thing I'll mention, because we talked a little bit about searching. Our examiners are actually available for helping on searching. We actually have, there's searchers at the USPTO that will sometimes go to our examiners to help on a search. I've had people ask me about searches, and what I do? I call on the examiners at the PTO to help me on the search, and I just relay it back to those people. So we're able to help. We can't find the prior art that your invention is, but if you give us an idea of what your invention is, we can give you some guidance on where to find it, so that you'll know if it's worth it to actually file an application with the PTO. Because if before you even file, you need to think about, is it really worth it, and is it already been done before?
So Lance, to your point about like fees and things like that, hiring an attorney isn't always necessary, especially for the patent search. You could get maybe 80% of the way there, finding a lot of stuff to say, I see 100 things that look very similar to what my invention is. Maybe it doesn't make sense. But if you don't see anything, well, maybe it does make sense. So, you can do some of that yourself, check existing products in the market. You don't need to hire an attorney to do the search. So, the whole issue about patenting, to the lady's point, it's an individual choice based upon the nature of your product.
So ultimately, and the burden is on the examiner on the patents, so they're filed. And I think that this is where we've gotten ourselves a little bit in trouble, because our examiners are overworked, because the burden is on them to find out these applications, and there's so many applications coming in the door. But this is what we're doing. We're going out, we're finding our prior art. If we're not finding the prior art, you're getting your patent. So that's why it's great for you to kind of do a little bit of legwork at first to see if there's anything out there. So you can give that to the examiner, they can make some determinations, and it'll make the process a lot smoother.
So, maybe this is a weird question, but when you were an examiner, objectively, did you feel you were seeing a lot of frivolous patents, things that people were filing either because they got in touch with unscrupulous people, said, oh, you should file a patent because somebody had an economic motivation to have them file, or, ooh, I want to file because I'm supposed to?
I would say that there are, when I was an examiner, I was like, really? This again? And sometimes it's the same companies, and you're like, why are they filing so many applications, and they all seem to be the same thing? So you can imagine how challenging that can be for an examiner. They're like, really, again? But I would say that, I think one thing that we've been trying to do is educate our examiners how these patents can affect companies, how these patents can affect independent inventors and that sort of thing. And these things can be very important, even though when you file it with us, it just doesn't seem much. It doesn't seem like much to us. But how are we supposed to know that? We don't know that. It really depends on the company, the inventor. What are they looking to do?
Just curious. What are all the resources for doing patent searches besides Google Patents? This is more for international.
Well, there's actually, as an examiner, I would actually sometimes use Espasnet, which is a European website. But Google Patents actually has foreign patents on it now, which is great. So you could actually start there. We're working right now. We're creating a new classification system in cooperation with Europe and also other countries to create a unified classification system that we can actually, so you can search by classification, because sometimes it can be hard to, people call things different, use different language or to call things, so it can be hard to find things just doing a word search. So classification search can be very beneficial. So we're working right now to have a more cooperative patent classification system.
Can you talk a minute on Bruce's point about frivolous patents and patents that are filed for economic gain, usually for a patent attorney? If a utility patent has been rejected, I often hear, well, let's get a design patent. And to me, that unless it's something that is, it's all about style, that's just a waste of money. I mean, you're shaking your head, do you,
I would say that, I mean, designs are meant for, you know, the style, the look and the feel of it.
Right.
So, you know, that's why I think Apple was like so much about design patents, because their whole product is very much about the look and the feel. There's a lot more to it than that, but that's how they were getting their market share. It's about the look and the feel of these products. So, I know, I agree. I don't necessarily think that that's the answer. I mean, if you can't get your utility patent, that doesn't mean you can't go to the market with your product. You're just not going to have that patent protection.
So does the phrase that I hear a lot with trademarks apply to design patents, likelihood for confusion? Where it used to be people thought, oh, I'll just tweak something small and I'll get around somebody else's design patent. But is that
Honestly,
a criteria?
I don't know enough about the design patents. And
Dave
how,
or Louis?
It's the same standard, but like anything else with design, you're tweaking around what you see. So the first thing you have to look at is what made that design different than the rest of the designs they got a design patent. And that's sort of almost harder than it is with a regular code. You have to sort of look through all the pictures and figure out what's different. And then it's knocking off that piece is the problem. That's not moving. So it's easier to get, but it's harder to sort of sort out what's the difference. You have to literally go through the whole pile of the example and figure out what's different between A and B.
sounds about right. So this is actually some of our proprietary search systems that we have, although not all are proprietary, but IEEE, our examiners use these things, but our proprietary ones are East and West, and those are the ones that we have only at the PTO. We have those only at the PTO because, I mean, ultimately, we're actually hoping to convert to a system that we can wide release, but the problem right now is, you know, bandwidth issues. Our systems are completely outdated, our IT systems. So actually wide releasing things are just gonna cause too much burden on our systems to do that. But you can go to the PTO and use them. Yeah.
I was wondering how thorough, I mean, how much time does an examiner spend reading the body descriptive? You know, if you have, if I've cited 30 different references of prior art, and then I talk about the whole history of the, you know, of the field with each thing and why mine is improvement of this.
I would just ask you not to do that.
So, I mean, how useful is that whole body of description to you versus the claims themselves?
I would say that description and the state of the art, if you can do it in a very concise manner, is very useful to the examiner, because they can understand where you're coming from. And when you have a provisional application, you know, it's almost like selling it to the examiner, why this is new, why this is different than the prior art. You know, explaining that to the examiner can be very useful. The amount of time an examiner has it depends on the technology. The more mechanical technologies, they have very little time. The more electrical, biotech technologies, they have more time. I think our computer science area, they have like twice as much time, if not times as much time as our mechanical areas.
So that's useful background then when you get to creative claims.
Background.
Is that how it works, or is there some other function that serves?
Well, I think it kind of gives the examiner a point to start, to be like, you introduce this idea of what you're doing and why it's different than the other things, and it helps them frame their search potentially. It helps them, you know, interpret the claims so that they understand what you're doing, and it gives them a good frame of reference.
You touched on the design patent before, so let's say you have a certain design, but the actual product itself that you're designing for is sort of completely different functionality than something that previously exists. That sometimes influence whether you patent it or not. Let's say something does X, but it's because popular design trends, industrial design say, like, this is something that people are responding to, this kind of look. If you're doing something completely different with whatever housing, that's something that might.
No, I mean, with design, it really just is about the look and feel. What's going on out there doesn't really matter. So if it's a new look or feel, then yeah, that's design. It's just the look and the feel exclusively. Oh, it doesn't seem like I answered your question. All right, let's get to some good stuff. We talked a little bit about this, but trade secrets. I'll just talk. So trade secret law, it is actually a state law. It's not governed by the PTO, but we're somewhat active in this area as well because intellectual property, it's a form of intellectual property. But valuable business information that gives a competitive advantage. And trade secrets need to be protected in order to have that sort of, in order to be able to say somebody stole it, you need to be able to really protect it. That's why, Coca-Cola, I mean, they protect that secret very well. But different types of trade secrets that might be, yours, like manufacturing process, business strategy, client lists, those are all things that could potentially be trade secrets. But in order for them to be considered trade secrets, you need to actively protect them. You need to have people if you have a company, sign non-disclosure agreements and refresh that non-disclosure agreement every 60 years, and then 6 months to 1 year. These are things you have to do in order to keep it as, say that you're protecting your secrets.
So you said somebody stole Coca-Cola's formula. Coca-Cola would have to prove that you did something criminal in terms of stealing it, or you violated an agreement.
Yeah.
So, like you broke into their facilities and stole their formula. They're not entitled to it just being a trade secret. Excuse me?
Someone actually stole the secret for Coke, gave it to Pepsi. Pepsi said, you know what?
Yeah.
We want to see it.
Yeah.
And they turned it. Pepsi actually turned it. And Coke prosecuted the full extent of the law.
And if Pepsi had taken it, they would have been prosecuted.
But yes, but that's what you do. Trade secrets, they don't run out.
Yeah.
When the patent, the world to know about it in 20 years.
And anybody can do it. And so, there are advantages for trade secrets that you don't get for patents. But then, if something can be reverse engineered, then it can't be a trade secret. I mean, that's it. I mean, you get no protection. Reverse independent, or independently developed. If somebody actually independently developed the Coke formula, that it would just no longer trade secret for Coke. Provisional applications. So basically, provisional are a way it's a low-cost way to kind of enter the PTO. You don't need claims. Drawings are useful. Specification, describing your invention is very useful. And I mentioned the 112, 35 USC 112. It's about description and enablement. So providing enough information so that when the examiner you file a non-provisional application and you have claims in that application, that the examiner finds everything in that provisional. So actually what I have told people before with respect to provisional is, think about what your claims would be, even if you don't want to draft them yourself. Think about what is your invention so that you make sure that everything is in there before you file your application. So you have a 12-month window after you file the provisional to make that decision whether you want to file that non-provisional application. And that 12-month window, after that window, the application's abandoned. Some people say file early, file often, so you can always just file lots of provisional applications. Yeah.
Does new matter count for edited matter? Say you have something written out and you modify it or change a drawing or change some small specifications. Does that lose your priority date?
If you do that in the non-provisional?
No, in the 1 year and the 12 months.
Well, you would actually have to file a new application if you're changing something in the provisional. You can't just add something to the provisional application.
Even if it's just modifying the...
Well, I would say you can't file anything else. Once it's through the door, it's there. It's not to be modified. So you would actually have to file a new application. So it's really important to kind of think it through and make sure you have, and if any modification that you actually have, is it really needed for the claimed invention later on? Because maybe it's not.
Yes?
Do you have sales before you file the provisional?
You should not have sales. You should not sell your product. Is that what you? Yeah. Once you've sold your product, you've lost the ability to have the patent.
Forever.
forever.
And that was a big change in the American Invents Act in terms of, because we're
On
all-
sale, I'm trying to remember what 102, I mean, on sale bar is,
wasn't it a 12 month?
yeah, I don't know
It used to be
if,
on sale in the United States only.
okay,
Okay.
Now
yeah,
it's on sale anywhere in the world.
yeah. Yeah, I was thinking that it was always on sale bar.
I'm puzzled. You were talking about commercial success before?
Yeah.
Isn't that selling?
Well, once you filed your provisional application, you shouldn't just stop there and wait for your patent. You should go out and you should sell it. You should do what you want to do with it. And at that point,
But can you get a patent then?
well, you could get a patent, you know, what the prior art has, and if you're extremely, extremely successful, and the examiner has made a rejection that is a 103 rejection, then potentially the commercial success can be used to overcome that rejection.
That's
Now,
that's not what I'm asking. I'm asking, you're saying you can't sell, and then you're saying you can sell
you can sell
After the provisional.
after the provisional.
after the provision.
After, I mean, if you want to have a patent, you cannot sell your product until you filed something at the USPTO.
You
But
should
once
not
you
present your
file,
product commercially.
yes.
And then file, especially because first to invent used to be, now it's first to file.
Right.
So you have no assurance that if you feel you're entitled to the patent, if it's shown to the world, somebody might beat you to the punch and try and file ahead of you.
Right.
It's really a matter of keeping it confidential
Yeah, sure.
before you file your patent. Yeah.
So when you make drawings, you can't add any other drawings to your regular patent, your regular patent application once you.
I wouldn't say you can't, I mean, so basically your provisional application is supposed to define what you potentially want to claim in your later non-provisional application. So when you file your non-provisional, if you want to add some stuff, hopefully any claims that you have are supported by the original, and then you get that priority. If the claims aren't supported by the original, or maybe some of the claims are supported by the original and some of the claims are not, then you have a situation where you just have different claims with different priority. And that's, I mean, examiners deal with that sometimes, but it's, you know, it can be hard for examiners to deal with that. But you want to make sure as much information is in that provisional as possible. You can improve upon it, you just need to make sure that as much information is in there as possible.
You said you can file several provisional patents, correct?
Yes.
Why wouldn't you just do that indefinitely?
Huh?
Why wouldn't you just do that indefinitely?
You could certainly do it indefinitely, but you're never going to get any patent protection from those. You're just going to be able to say patent pending on your product for a very long time.
And it would only be for the most recent date as the prior art date, or the priority date. We have about 15 minutes left, so,
okay.
We'll save some time for Q&A.
So, provisional, okay, 65 for microentity, I had it wrong, I don't know what I was thinking. For low cost submission, so if you file as a qualify as a microentity, has not been named an inventor on more than 4 previously filed applications, this microentity is really for the independent inventor, the new independent inventor. And then, of course, the income level is income exceeding 3 times median income household. And then the last one has to do with actually conveying that patent to somebody else at some point, before you file. So, you know, it has to be your patent. You can't have already sold it to somebody else. So basically the provisional is really about giving you time to think about what makes the most sense. That's why it's a low cost of entry. That's why it's about getting a foot in the door. So, give you to investigate market potential and make improvements. But like I said, you need to be careful about too much change because that could result in the loss of the provisional filing date. That's just a consideration. That's the kind of the world we live in now. When an examiner picks up an application, typically they'll look at the provisional if they find prior art that kind of is in between. You know, if they find some prior art that's after the filing date of the provisional, But before the filing date of the non-provisional, the examiner will look at the provisional to ensure their support for what's being claimed. Yeah.
How long before you file a provisional utility patent, before you get response back from you that you have it? Does the clock start when I get my letter? Like you said, this gentleman, oh, you know, when we get it, when we start, it might take us a year.
Well, the provisional is just it's just a placeholder at the PTO.
Well,
The
when
date
the
you
clock
file it is the date that year starts.
Oh, I got it.
So you should get like a notice of filing, a notice of receipt of some sort from the PTO, and it's that date where that year starts.
And they can be filed online, provisionals, or do they have to?
Yeah, everything can be filed online these days. All right, and of course I mentioned patent pending can be used. So last year we received 163,000 provisionals. I anticipate with the new change in the law to first to file, we will probably have an uptick on that this year. Placeholder. So provisionals, basically you don't have to worry about the claims, but like I said, I would encourage you to think about what your invention is and what your claims are.
Out of the 163,000 last year, you said?
Mhm.
Do you have a guesstimation in your 15 years, how many actually got their patents out of that number?
Oh, no. I mean, a lot of people.
Half?
Well, I would say that they have to convert to the non-provisional state, and many of the applications never do. So it would. Yeah, I'm not sure if we have that data as far as how many actually convert. So I mentioned to you before that provisionals can be a basis of priority, of course, from the U.S., but also foreign priority through the Paris Convention and then the PCT. So we mentioned that before. The requirements must satisfy 1 at 112. I actually did a talk at Cooper Union just a month or two ago, actually focusing exclusively on provisional applications. If you're interested in filing a provisional application, look at my website, find the talk, just kind of go through it. And if you have any questions, feel free, because this is something you really need to disclose this information. And the more you know, the better position you are, whether you find an attorney or not. So I'll talk very briefly, American Invents Act. The big thing here is a first inventor to file. So we transitioned to a first inventor to file in March of this year. And that means basically the first to the PTO is going to get the applications. And sometimes people are working on the same things. They're not stealing from each other. They're just working on the same things. They come up with the same idea. So it's a race to the PTO at this point, which is the same as the rest of the world. We were the only country that was the first to invent. So that harmonized us with the rest of the world. This is our new statutory framework. Basically, don't really care about that. So we're in a transition point here at the PTO where we have cases that were first to invent, and we're going to have cases that are first to file. We're going to have cases that were first to invent and first to file. So we got a lot going on here, so we're trying to balance it all. I think it makes it ultimately simpler for the inventor, although maybe not necessarily as inventor friendly. So I think it's just about we're about getting the word out there to educate people on the change so that they can know what's going on. And I think resources. So there's actually a lot of training on the USPTO website on the first to invent stuff. A lot of videos, slides, there's so much information there. I was like, wow, I had no idea. The Inventors Resources page, tons of information there for patents, trademarks, whatever you want. Actually, I brought out the scam prevention. We actually have a website that's devoted to where people bring stuff for us about invention submission companies, and we'll post it on our website. We send it to another agency in the PTO to kind of go after those companies. If you see a company that an invention submission company that has the USPTO seal, email me. No company should be using the USPTO seal. The nonprofit like IMA, yeah, we partner with nonprofits. That's fine. They're allowed to use our seal, but no company should have our seal on the website. So we do not endorse any sort of invention submission company. And then pro se, pro bono information is also available, and you can find that on our USPTO website. Going through past. And I think that's it. Yeah.
A lot of detail, thank you. And I know there